In order. Mr. Frazee, would you lead us in the pledge, please? Please rise, put your hand over your heart.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This time we'll observe a moment of silence. Madam Secretary, call the roll, please.
Hasjev? Guston? Zadra, absent. Sfraza? Dorch? Hazy, absent. Kishel.
Here. We have a quorum. Ladies and gentlemen, I call this meeting today because we had voted on an agreement to send RTC with some changes. And when I got a copy of what they did, and they had proposed another couple of changes, I visited with with the city manager and Councilman Hasheff, along with legal counsel, and I felt that the changes were significant enough that we needed to bring this back for discussion with the council. So that's why this meeting was called. Also, I want to disclose on this item 5.
Mr.
Item
Mayor,
5. Yes,
Tracy
ma'am.
Chase, Reno City Attorney's Office. Under open meeting law, you need to take public comment first before
Okay.
you call item 5.
All right. Thank you very much. I don't need to disclose before.
No, when the item's called, Mr.
Okay.
Mayor.
Thank you very much. So now we're going to public comment. Michael Snell,
Those are on the actual item.
this is on item A5. Excuse me, we have to do, let me get public comment. I have no public comment cards. Now we'll talk about the issues. Item A5, sorry about that. Yes, we should get that. Motion to approve the agenda. All in favor say aye. Those that oppose, no. Motion carries unanimously. Now, Mr. Snell.
Mr.
Item
Mayor,
A5.
now your disclosure would be appropriate.
Now I disclose before you speak, sir. At this time, I need to disclose to the public that my son, Robert A. Cashel Jr., has an interest in North Point Sierra, Inc., which is a tenant of Petro Shopping Centers Limited Partnership and TA Operating, LLC, which company owns and operates the Alamo Truck Stop located in Sparks, Nevada. The record owner of the property is HPT PSC Properties Trust. North Point operates the gaming, the bar, the restaurant, and the Super 8. TA Operating LLC operates the gas islands, the diesel islands, the store, and truck repairs. Neither myself or North Point has any interest in the real property, fuel, or other operations at TA Operating. North Point does pay me on a promissory note dated in 2008 relating to a stock redemption from the sale of my interest in the company. The note is at a fixed rate. There is no fluctuation in the note payment based upon gross receipts or revenues of North Point. The matter before the City Council relates to an agreement permitting construction of the Southeast Connector on the Rosewood Lakes Golf Course located in the city of Reno. This agreement does not speak to, nor does it relate to the alignment of the Southeast Connector through the city of Reno or Sparks, which is a different jurisdiction. Neither myself, my son, or North Point has any financial interest in the transaction being considered by City Council, which allows the RTC to enter the Rosewood Lake Golf Course to construct the Southeast Connector. Additionally, I have no facts or reason to believe that Council's consideration and voting on this matter provides any benefit or detriment to North Point that is greater than accruing to any other member of the general business profession, occupation, or group that is affected. And after visiting with Ethics and Legal Counsel, I do not have to recuse myself.
Tracy Chase, Reno City Attorney's Office. Yes, pursuant to the NRS that governs disclosures and abstention, disclosure is recommended by our office. However, upon the facts provided, abstention is not required.
Thank you very much. Now we're talking about item A5. Mr. Snell.
For the record, I'm Mike Snell. I live in the city of Reno. City Council, we have 7 members, 4 of you are termed out. Washoe County Commission has 5 members, 2 of them are termed out. The same 2 commissioners pushing for this road are choosing not to run again. 5 members, 3 seats open. Over half of the county commission and city will not be in office when ground is broken on this road. We see government in action. We're spending money we don't have on a road we don't want nor need based on current population and traffic statistics, and all the project seems to be based on pre-recession statistics. I would like to add one other thing. In our various community meetings with Mr. Oxel, we were told that there would be very little additional truck traffic on this southeast connector. However, in seeing the TV spot with America Shell and Lee Gibson on channel 213, 217 of Charter Cable, we see that Mr. Gibson talks about the southeast connector providing an alternate route for trucks to prevent them from having to go through the Spaghetti Bowl and down 395. So this is a pretty strong conflict. And that's all I have to say. Thank you very much.
Thank you very much. Dimitri Hallerback. Good
morning, council members. My name is Dimitri Hallerbach. I'm a resident of Hidden Valley, and for the record, I do oppose the Southeast Connector for the following reasons. One, the dramatic development that RTC bases the traffic models on is fantasy. Just because land is zoned for a particular use and population density doesn't mean that it will actually be built. The current Great Recession with the Great Recession, any hope of development, even at 50% of what was envisioned, has been delayed by at least 10 to 15 years, if not indefinitely. Secondly, the widening of McCarran, which has already started, and the proper use of traffic light timing and access controls, which to date the RTC has actually failed miserably at, could provide adequate, perhaps not perfect, but adequate traffic flow for the foreseeable future within the timeframes of the RTC's 2040 plan. And finally, given the above, there has to be a better use for the $1/3 to $1/2 billion that this project will ultimately cost. The city may not pay for this directly, but city residents will certainly be paying for this. So regardless of my views on the SAC, the decision facing the council today is whether to approve the SEC contingent on a large number of uncertain events. My question to the council is, why the rush? It is my understanding that there was supposed to be a public hearing on this, presumably at a time when, other than the middle of the day, when interested parties are not at work. It's also my understanding that the Corps of Engineers has not approved this project, so why not wait for that approval? And furthermore, by making this agreement, the city is putting $7.5 million at risk should the project ultimately not be approved by the Corps or other entities. And lastly, the RTC does intend to use bonds to finance the construction of the SEC. The city has not had a good track record with bonds from the baseball stadium to the star bonds for the Cabela's. Similarly, Sparks is having serious problems with the star bonds for the Legends development. The question is, has the RTC clearly articulated how it intends to pay for the bonds? Again, the city may not be directly on the hook for this, but should the RTC default, you can be certain that the residents of Reno and the communities around here are going to be on the hook for that. So, in conclusion, I do urge the council to delay approval of the SEC until the project is actually permitted, until the city understands whether the $7.5 million will be at risk based on those approvals, and until the RTC can prove, better than Cabela's, the Reno Aces, and Legends did, that the area residents will not be on the hook to bondholders. Thank you.
Thank you. Vern Schultz?
Good morning. My name is Vern Schultz. I am a resident of the Rosewood Lake Homeowners Association and serve as treasurer on the board of directors. Due to the short notice, however, given for this meeting, I'm not speaking for the association. I am here to present a concern about the council's upcoming action on the Southeast Connector and the Rosewood Lakes Golf Course. First, I would like to present some facts about the route which the RTC has selected through the golf course. The RTC permit application states that they will be destroying about 8 acres of wetland. I recently received a research study funded by the National Science Foundation. This study, which I have attached to my written comments over there, were designed to show that impacts of mitigation attempts where wetlands have been destroyed. This study looked at off-site restoration efforts such as those proposed by the RTC. Their conclusions are applicable to wetlands in the golf course. The following are verbatim excerpts from the study. Analysis of restoration projects show that restored wetlands seldom reach the quality of natural wetlands. Once you degrade a wetland, it doesn't recover the normal assemblage of plants or its rich stores of organic soil carbon, which both affect the natural cycles of water and nutrients for many years. Even after 100 years, the restored wetland is still different from what was there before, and it may never recover. The author, a PhD from the University of California at Berkeley, concluded, to preserve the wetland, don't degrade the wetland. With this as one of the many impacts that will be caused by the Southeast Connector, I request the council ask the Corps of Engineers, who have the permit authority, to prepare an environmental impact statement prior to issuance of the permit. With the loss of population over the past 3 years and the reduced population growth projections, the urgency for building this road is greatly diminished. Therefore, there is adequate time to study all of the impacts of this proposal. After all, if the project, if the project is built now, the bonds have to be issued, and we'll be paying interest on a $200 million project many years before it is needed. In addition, the city will be obligated to pay an estimated $100,000 annually for maintenance of the road. This makes no financial sense and is fiscally irresponsible. I did want to make a comment about the mayor's potential conflict of interest. I'm not an attorney, but based on the Supreme Court decision on Kerrigan, my understanding of that decision was that even a non-financial interest, a family interest, would be sufficient to call that a conflict. If I'm incorrect, according to the city attorney, so be it. But that was my understanding. And at least on a logical standpoint, it seems to me, even if the mayor's son is involved, there is a conflict. And again, it may be a legal issue, but it looks to me from a public perception that there may be a conflict. And, you know, you can rule on that as you want.
All right, thank you very much.
Anyway, thank you for your attention and opportunity to present my comments.
Kim Rodemeyer.
Good morning. My name is Kimberly Rodemeyer. I have no idea why I'm constantly surprised at this council's actions when it comes to sticking it to Upper Southeast Reno, yet here we are again. With 3 days' notice, an agenda was put out for possible action by this body for discussion, review, direction, and possible approval of agreement permitting construction of the Southeast Connector on Rosewood Lakes Golf Course. This council seems ready, willing, and even excited to spend taxpayer money on moving, or the preferred plan of deleting, 9 holes of a golf course that was specifically designed and designated to hold floodwaters for the protection of the surrounding communities without any permit approvals from the Army Corps of Engineers. After speaking with the Army Corps of Engineers, we have been told that they have not even looked at current RTC submissions and have no plans to look at them anytime soon. In addition, this is just the beginning of a very long process. Through the Freedom of Information Act, we have received copies of all the public comment that was submitted to the Corps, and there are numerous issues that will have to be addressed satisfactorily by RTC before permits are even considered. If they determine that an EIS is required, then the process will be even longer. We have not even received our requested public hearing yet by the Corps. There is no guarantee that permits will be granted. Yet the City Council is rushing headlong to follow RTC and spending taxpayer money hand over fist on portions of a project you have no idea you will be allowed to finish. Also not addressed is the 1993 unanimous abandonment by RTC of the section of road between Miraloma and Cleanwater Way. In 1993, 4 years before the flood, the RTC received input from CFA, an engineering company, stating that, quote, given the golf course design as a detention basin and the location of extensive wetlands, the roadway would be extremely difficult and expensive to construct between Pembroke and Miraloma, unquote. And then, quote, the Regional Transportation Commission recognized this problem and in 1993 voted to abandon this portion of the alignment, unquote. This was followed by the Reno City Council's master plan amendment in June of 1996, 6 months before the flood, to uphold the recommendation of the City Planning Commission and the RTC to, quote, eliminate a proposed major arterial road between Miraloma Drive and Pembroke, unquote, which passed unanimously. It is blatantly obvious that the RTC of 1993 and the City Council of 1996 recognized the dangers and the ecological impacts of building a road through this area, even after doing a projected traffic study. Councilman Hascheff was one of them. Yet this RTC and this City Council are throwing Upper Southeast Reno under the literal bus yet again. I cannot stress enough that RTC does not have Corps permits yet. They may never get them. You could be wasting millions in taxpayer dollars by taking the steps you have been taking, which in turn could follow by legal action. This will be your legacy. This 250-page document was the public comment submitted to the Corps by the US ECC. This 200-page document obtained through FOIA were the other public comments that do not include our comments. All of this has to be addressed by the Corps and RTC. Did you really think that this process was going to go as fast as you wanted it to go? Thank you.
Thank you. Terry Thomas.
Good morning, Mr. Mayor and members of the council. Terry Thomas for the record. My concerns are twofold today. First is a financial concern. Maybe the City of Reno's policies for agenda items differs from that of the City of Sparks, where they used to get the finance director and the city manager to sign off on items that had a financial impact. I see that the agreement permitting construction of the Southeast Connector on Rosewood Lakes Golf Course appears to have been signed off by attorneys and engineers. Quite honestly, that's how the City of Sparks got into trouble with its star bonds. This evokes concern on my part because if the finance director is not in this loop, it means that your constituents, in other words, our taxpayers, are not being represented. Has your finance director indicated how this payment will be safeguarded in the event the Southeast Connector does not receive approval and the monies have then disappeared into a rabbit hole in the city's general fund? Just saying, your most recent audit report was less than stellar. Now to the abandonment of the right-of-way for the SEC through the needed thoroughfare between Miraloma and Pembroke. Please review the staff reports and supporting documentation that accompanied your action on Resolution 5241 in 1996, to wit, a memorandum from Lionel Sawyer and Collins, dated March 30, 1995, to Ms. Laura Tuttle, your supervising planner at the time, stated that the Regional Transportation Committee voted to delete the portion of the then called Tahoe Pyramid Link, which goes through Rosewood Lakes development, and adopted an alignment which avoids conflict with the area. In pertinent part, the memorandum concluded, and I quote, the Tahoe Pyramid Link, as it is currently shown on the master plan, is no longer viable and has been rejected by the Regional Transportation Commission. Your city clerk has been unable to provide any evidence that this action has been amended or rescinded by the City Council. Are you really ready to take this step to commit to an agreement for a highway that is completely speculative? for a payment that has no basis in the usual or legal sense, as in an appraised value or fair market value, and therefore takes on the appearance of a loan. A payment that is conditional through property you don't own, have disavowed as being viable for the purpose you intend, and for which you will require the dismantling of one of the only public golf courses in Reno and the only one remotely close to our southeast community. Thank you.
Thank you very much. Mike Trudell?
Good morning, Mayor Cashel, members of the City Council. For the record, my name is Mike Trudell. I live at 4390 San Gabriel Drive in Reno. I just have a couple of comments. I appreciate that the council must make difficult decisions on a regular basis that affect people's property and their property rights. It's my understanding that today's agreement is what's on your agenda today, and that this agreement is designed to reserve rights for the city of Reno. And so I would support that. I strongly support sound planning and good business judgment, and Councilwoman Safraza and Councilman Hascheff had requested that additional traffic studies be done regarding the area around the Southeast Connector and McCarran. And I don't know if that has been done yet, but I believe that the construction of the Southeast Connector may be premature given the improvements to 395 and McCarran, and that further study is warranted. I hope that the city will continue to obtain approval, though, to cross the Truckee River if and when federal monies become available to construct a bridge, and that could possibly be done with the flood control improvements. And with that, I'll conclude my comments. Thank you very much.
Okay, thank you very much. Have no other public comment cards? You have any? Okay, I'll close the public comment section, bring it back to the table. Staff, you want to come up and go through the changes that this was agreed to by 6-1 vote at our last council meeting, I think it was, and then it was sent forward, and then I checked with you when I found out there were some significant changes. So if you would go through those. And
sure.
let's look at them.
For the record, John Shipman, Deputy City Attorney, just as a brief history here, what had happened at the last council meeting is the agreement was approved with some direction to staff in terms of some additional language being plugged into the agreement. It's essentially that was to some language regarding local permits and the RTC's requirement to follow local permits. Some language that would protect the city's legislative discretion in the future, and then to true up some of the hold harmless language and the indemnity language to make it less open-ended and kind of more tailor-made. As Mr. Mayor, as you mentioned, the staff did that, went through the exercise, consulted with RTC. One concern they had was in the event that at some point in the future, if the City Council were to change its mind and not issue a permit, they would have paid $7.5 million and not had a project at that point in time. So they wanted some assurances that if that were to happen in the future, then there would be a requirement to reimburse the RTC for the $7.5 million so that they weren't left without a project and $7.5 million out of pocket. So, and then since then, and Madam Clerk, if you could just turn on the overhead real quick. This has been moving rather fast, but I just wanted to point out what the proposed changes are, some additional changes we'd like to make at the table. The first one is to add some language that the city reserves the right to request for the RTC to pay for and negotiate with the RTC regarding the cost of acquiring any fill or dirt that might be required later on when the golf course, if and when the golf course is rebuilt. So that would go in the agreement. And then also to modify Section 9, and I just consulted with counsel for RTC, John Fowler, and what we would like, and I think we've tendered a document in front of council that represents this. There's two minor changes to that document, or two changes I'd like to point out. The first one is about halfway down the page, and it begins, the sentence begins, or the clause begins, which prohibits denies the RTC construction of the Southeast project. That language needs to come out because it creates a potential instance where if there's a disapproval of the interlocal agreement, the POP agreement, it would provide a loophole here that RTC frankly wasn't comfortable with, so we request that that portion of the language be redacted. And then also down in the following section, the following portion of that, instead of not construct, it should be begin construction by 7 years. And again, that's another issue where what happens if construction begins in year 6 and it's a couple-year project. So those were their requests in regard to that language. So again, with these additional changes, we'd request direction discussion from council to approve the agreement. So.
Yeah, first, Mr. Mayor, I do want to make a comment because obviously this project is in my ward, and I do want to say that I did not schedule this meeting. It was put together in 3 days and noticed. I had nothing to do with scheduling the meeting. I think the fair thing to do would have been to have a night hearing and to have all these issues addressed, and I appreciate all of you coming down during the work time to come and testify. I got several emails as well. One of the questions I would have for the city attorneys, and I don't know, Jonathan, if you could put this resolution, I did check with the city clerk, was on the amendment which was approved by the Reno City Council that essentially eliminated the Southeast Connector, was approved unanimously, and it wasn't just any resolution, it was a resolution to actually change the master plan. So this was done through a master plan, which obviously we have to do through a land use case hearing. It requires a public hearing in order to change the master plan, and there is nowhere I could find. I spent hours and hours looking to see when council changed this, made an amendment to the master plan to allow the Southeast Connector to go forward. So based on that, Jonathan, how could we possibly legally accept $7.5 million and then say, well, we're going to truly have a, wouldn't the council be conflicted out to hearing a land use case to change the master plan for a road when we've already prematurely taken $7.5 million without having any public process, no public hearing, no mitigation on the alignment of the road, no additional studies to change what the original proposal was on the land use growth in this community? How could we possibly remain objective when the council's already entering into an agreement with RTC to accept $7.5 million and then, oh, later on we'll hear the master plan? What's the chance of that being changed?
I guess I'll answer that kind of from a legal perspective, or at least that's the piece I can add. What this agreement does is, it makes sure that you have the legislative discretion in the future. If the master plan amendment is required, you have the authority under this to, exercise your legislative discretion. RTC has a requirement to comply with getting that master plan approval. From a policy standpoint, what it does is it says, if it comes back and the city does something to deny the project moving forward within this 7-year time frame, then the city will be on the hook for that to repay the $7.5 million. So it becomes.
I mean, I could see where there would be a case by the neighborhood that they couldn't possibly have an objective public hearing by this body for a master plan amendment when the city council has already entered into an agreement with the RTC to accept $7.5 million. I mean, I think the residents can argue that a case could be made that they're not getting a fair hearing on this issue.
Yeah, Councilmember, I don't disagree with you. I mean, there can always be people who, constituents and interested parties who believe that, a public body is biased either for proper or improper reasons, and they can file complaints, and take it up with ethics boards or file court cases. That's just the nature of the political process.
So I would like to know what approvals then, Jonathan, I'm assuming since you've brought this legal agreement forward, that you've done all the due diligence to look what additional approvals would be needed by this council for the actual alignment to go through.
For the alignment, it's my understanding after speaking with RTC extensively, the city is never in a position to approve an alignment per se. That is actually the purview of the RTC that does that. What the city does and what the city has done, and as we talked about in the last meeting, is approve a programmatic agreement, the POP agreement. And by approving the POP agreement, that allows the expenditure of gas tax for a particular project. And that is approved off by the different jurisdictions. This is an agreement that's akin to a property acquisition agreement, as if the RTC were to essentially going in and buying a piece of property that it needed for a road. It's not actually...
Let me ask the question a different way. Is the Rosewood Lakes Golf Course already master planned to include the alignment based on the decision made by the council in 1996?
I'd have to defer to staff on that. I'm not in a position to speak to that.
So shouldn't we be looking at those types of issues before we prematurely approve an agreement for $7.5 million? I mean, you're our legal counsel. I mean, shouldn't we look at all the permits and the necessary entitlements that we would need to approve before this comes to us?
Sure, that is certainly your prerogative to do that in terms of, delaying this. What this agreement does, though, and what the direction that staff was given, is to provide kind of a broad blanket. You can do it either way. You can do it up front and not, go forward with that master plan thing and approve this before that, or under this agreement, the RTC still is required, if a master plan amendment is required, to come back to you to file for it, and and it will be up to you to approve it at that point in time. So that's a policy decision. That's well within your purview. Legally, we've got it set up so you can do them either in parallel. You can do one before the other, however you want to do that.
Well, I guess I'd like to hear from our city attorney on that, because that seems contradictory to any land use hearing case that we've ever had. Any public hearing, we typically go through a public process, and it's quite a lengthy public process. There's certain findings that this council has to make before we do a master plan amendment or a zone change for a major road. And so I'd like to hear from our city attorney's office if that's truly the case, if we can prematurely accept a payment for $7.5 million before we go through a public process to hear the actual alignment and conditions. If this road were to go forward, maybe this council would be putting additional mitigation factors in there, maybe based on all the testimony. Here's the public request for the Corps of Engineers. It's over 200 pages long from all the different entities and agencies that would be affected in this process. So I want to know from the city attorneys if that's the case, because that seems like it's a different opinion from other land use cases that we've had at this council in the past.
I stand by what my deputy, Mr. Shipman, has said. I support Mr. Shipman. I think he is correct in everything he has said, and that's what I'm going to say on the matter. I support him, and I think that is the appropriate thing to do, because I think he's done everything that is necessary to be done.
Okay. That's all I have for now, Mr. Mayor.
Yes,
Let's
Mr.
have a
Ashcraft.
discussion about that, because what I understood is, and what we approved at the last meeting, was to make sure we had our discretion on any permit or entitlement that came back to council. What the RTC did is said, okay, if you do that, then we want the money back.
No, to clarify, the RTC is not requesting that if you put a condition on a permit, or if you put, and it makes it more expensive to comply with a permit, for instance, that would amount to an action that would trigger the reimbursement of the $7.5 million. What their concern is that if a permit was denied arbitrarily and capriciously, for whatever reason, that made it impossible for them to proceed with the construction of the project at that point in time, that's when this provision would trigger. And again, it's under the new language that's being presented today. There's a 7-year time bar on that. So that would have that liability, that contingent liability, evaporates after about 7 years with the.
Yeah, but I guess to Jessica's point, in the future, whether it's us or another council, they retain the discretion to deny any permit, any master plan, any entitlement whatsoever with respect to this road. So we're not giving up the right to have public hearings.
Correct.
You know, there was a master plan change in 1996 to take it out. If they have to come back before council for a master plan change or any entitlement, we still reserve the right to make the decision. And that includes denying the project.
Correct. Exactly. The issue you run into and the issue is if there is a denial and it stops the project and it frustrates it, it makes it impossible to move forward, and it's within this time frame, then there's a consequence to that decision, and the consequence is that you have to pay back the $7.5 million.
And that only applies now within a 7-year period.
Correct.
So my question to you is, there was a change that you put up on the screen that does cause me concern, because the example that I was concerned about is if, let's say, in order to make this road, the entitlements for the road would include another master plan change, maybe a regional plan change, maybe a zone change, maybe a series of special use permits, including cut and fills. And let's say a future council says, we're going to agree to all those changes, but we don't think we can make the findings on a special use permit for cut and fills. So although the project can go forward, it can't go forward with a special use permit with cut and fill, so it just makes the project more expensive for the RTC. That means that we haven't taken any action that denies the project. It just makes it more expensive. And by the RTC now asking us to take out that language that defines Reno disapproval, that does cause me concern, because I think we need to be very clear that the only way that this refund mechanism would kick in is if we took action that denied the project, the construction of the project.
Correct. And John Fowler and Lee Gibson from the RTC are here to speak on that, and I invite them up if you'd like to hear from them. The concern when I was speaking with Mr. Fowler is that the way that's currently written now with the POP agreement, you could imagine a situation where you deny the POP agreement, but that wouldn't in effect deny the project going forward. That would just mean they couldn't use fuel tax to make the project go forward. And part of the RTC's request is that you can't change the POP agreement in a way that would make it ineligible for the fuel tax to be used. So I'd put it to them. I think I don't think there's a huge difference between what the parties are seeing here. I think maybe it's a wording issue, and I'd put that to RTC if you'd like to comment on that.
Yes, for the record, John Fowler, General Counsel of the RTC. The intent of the language, the cross out there which says which prohibits and denies, et cetera, that the intent was exactly as was stated by Mr. Shipman. We just wanted to make sure that we didn't lose the ability to use the gas tax money on the Southeast Connector. It's an important funding portion of the project. And if you were to deny the POP agreement, yes, we could use other sources of income, but that's a crucial part of the financing for the project. As far as the permits are concerned, we're comfortable with the language that you see up there.
But doesn't that language, even with that language, already cover the situation? Because if the council were to change the POP agreement to basically to pull the Southeast Connector out, for example, as I understood it, refuse to approve the interlocal agreement, which is the POP agreement, because it contains the Southeast Connector, or remove it, that's what you're trying to prohibit. That's the issue you want to get to.
No, we're not trying to prohibit you from doing anything. It's just that the price for that action would be the refund.
Understood.
Right.
I should say for the refund mechanism. So maybe that language is better put at the permit, because really it's not fair to to have a provision that means that if the council didn't approve a special use permit for cut and fills, you could still go forward with the project, but somehow that's deemed a disapproval, and now the refund mechanism kicks in. So maybe Jonathan is right, it's a matter of wordsmithing, but I think if we're all on the same page on this, it needs to be very clear that, number one, the council retains whatever discretion they need to retain.
Right.
They can take any action, particularly a future council. And two, if it happens within 7 years that there is a denial of permit that basically does not allow you to construct the project, or there's the changes that you talk about to the POP agreement, which would be defined as Reno disapproval, then in that situation, if it happens within 7 years, then the refund mechanism kicks in.
And I think what you've just paraphrased the sentence beginning, if Reno denies or refuses to issue the RTC a permit or entitlement for or an approval of the Southeast Connector. I think that does what you just said. I'm not sure what additional wordsmithing, maybe I'm missing something, but I'm not sure
Well, there's two aspects of approval here. One is the POP agreement.
Correct.
And the other one is basically the entitlement process.
Correct.
Outside the POP agreement. And in that situation, when you're outside the POP agreement, it would have to be a denial of a permit that prohibits the construction of the Southeast Connector.
Refuses to issue a permit or entitlement for or an approval of the Southeast Connector. Yeah, I think that says that. If the denial of the permit stops the project, then that during the 7-year period, then that triggers the refund requirement.
Yeah, I'm not so sure I agree with that. So.
Okay. I'll be happy to work with.
No, I want to get this done one with the other because we got a meeting tomorrow, but I want to get some stuff. Mr. Hashef, let's go ahead and other people.
Why don't you have other people ask questions?
Ask questions. You think about what you were talking about, and if not, we might go into a recess and have you three go back there and figure out this language so we can talk about it.
Okay.
Because the cut and fills shouldn't, I mean, that shouldn't be a denial. Because it might run the expense up, but it shouldn't be a denial.
Yeah, I think if it just runs up the expense a little bit,
Right.
that shouldn't be a denial.
Okay.
I'd agree with that.
Anybody got any other questions? Okay.
For their attorney, I'm sorry, I didn't get your name.
Yes, John Fowler.
So, John, this would be an example. If the council didn't approve the master plan amendment that's needed for the road, would that constitute a denial and a refund of the $7.5 million?
If the effect of that, now I'm not the expert on the master plan amendment process, but if the denial of the amendment to the master plan would stop the project, then yes, I would think it would trigger a refund requirement.
Okay, so if the council couldn't make the findings, essentially, we would have to refund the $7.5 million.
I don't know what findings you would refer to, but if the effect of the action would be to stop the project, then we'd see it as a triggering of the refund requirement.
And Jonathan, is that the same opinion you have as well?
Yes, yes.
Okay.
Any other, Mr. Hashef?
It's back to me.
Excuse me, Mr. Guston, I meant to say, I'm sorry. Mr. Guston.
Thank you, Mr. Mayor. Mr. Gibson, can I ask you a couple of questions, please? And they seem to be reoccurring themes, but certainly concern of the people who spoke and you were here in the room. So let me ask you the current status of the core application. The 40, what is it? I wrote down the 404, section 404. What's the current status of that?
Back in May, the RTC submitted the 404 permit to the Corps of Engineers. It went to their regulatory division office. I understand it's in Carson City. It's under review right now. We've been working with the Corps. The Corps at the beginning of this project entered into an agreement with us, or just a working relationship with us, whereby they have been working throughout the planning and engineering design process in step with us to coordinate all of the issues with the resource agencies. Garth Oaksel is our project manager, though we understand the Corps is still looking at the issues, and we're probably 120 to 180 days out before a decision is going to be rendered on the permit.
Okay, so that, unless there's something pertinent to, other than, I was looking at the time frame, it's 120 to 180 days. That's still accurate, okay. Also in public comment, the reoccurring theme by a couple speakers was the source of funds and who's going to be on the hook for those. Maybe just a little treatise. I know
The funding for the Southeast Connector is coming from RTC motor fuel taxes and bonds that are pledged to be paid back by those motor fuel taxes. It's those motor fuel taxes that really, the requirements in the statute require that we come before you with the program of projects to have the entities approve all of those projects that'll go forward. And we did that this past year with that. So it's those source funds. There are no federal funds. There are no sales tax funds that are included in that funding plan for this project. And those funds are in place.
and the funds are in place.
Correct.
Okay. Next thing that came up is talking about, we're talking about 7 years here, but what is the building timeline?
It's my understanding, should we receive our permit in the next 120 to 180 days, we could be under construction sometime this summer. We have tried, and we are actually working through a process right now to look at an alternative delivery method so that we can expedite both the design and the construction to get this project moving. Just as a policy matter for the RTC, the funds, part of the funds are those fuel taxes that were approved by the voters in 2008, and sort of the policy direction from the RTC board has been to move those projects as quickly as possible so we can create jobs, and that's what we're trying to do with these fast-tracked alternative delivery methods. So if we don't get the permit, we'll go into an environmental impact statement. The environmental impact statement does not look at the alignment, it looks at hydrologic issues. It would take us about 1.5 to 2 years to complete that process, and at that time we believe we would then enter into construction.
So that 120, 180 days is in alliance with the core permit, but if it doesn't, then you go into the process. It takes about 2 years to go forward. And then some comments, and probably Garth is maybe a little bit better prepared to answer this, but either one of you, regarding the restoration of the wetlands, the pitfalls and the importance of getting back to achieving the wetlands back to the normal status. What can you tell us from your perspective, other than the conversation we had about in public comment, the presentation the gentleman made?
Yeah. For the record, Garth Oaksall, project manager with the RTC. The wetlands are obviously a concern of the project, the RTC and the residents in the area. There are established wetlands out there. We are impacting those. The actual, just for point of clarification, in our permit application, there's a little bit of clarification on wetlands versus streams versus ponds. I believe a comment was made that we were impacting 8 acres of wetlands. In reality, it's less than 2 acres of wetlands that are actually being impacted. The additional numbers are streams and ponds that we are bridging over or relocating as part of the Steamboat Creek restoration. So that's where there's a difference in there. So we're really talking less than 2 acres of actual wetlands that are directly impacted by the roadway. Now with that, the Army Corps of Engineers in their permitting process will condition the RTC on a number of criteria of what constitutes a successful wetland. Some of that will be hydrology, is there proper water flowing in there? Some of it will be proper vegetation and a diverse vegetation versus some of the wetlands out there now are infested with whitetop. They still classify as a wetland, but they're an extremely unhealthy wetland because they're infested with an invasive weed of the whitetop. Those would be the requirements of a diverse vegetative establishment. Some of the other requirements is that the vegetation would be trending upwards, meaning we're not seeing die-off. We're actually seeing the vegetation healthy. It's reseeding itself. It's repopulating the area. We'd also be looking at possible wildlife establishment. That could be conditions of the Corps permit. Again, I can't give you specifics on it because the Corps will condition us to meet levels of criteria that they deem successful for wetland establishment.
What I'm taking from what you're saying is right now they're not stable. They're regressing, is that what you're saying? And then you will at least stabilize those and have some positive growth or reestablishment. Was that what you're saying?
Absolutely, yes. Our goal right now is any measurement you want to take for a condition out there, when the project is done, we will see an improvement.
Okay. I have one other question which may be appropriate for you also.
also, I have two questions, but one more that Garth may be able to answer, and that is that I know we've had discussion at this table, the other council people have talked about when the improvement of McCarran comes, and I think it might have been an RTC meeting when it was proposed that, well, why don't we just make McCarran 10 lanes and take care of the whole thing and not worry about the traffic that's going to be on the Southeast Connector. So in public comment, it was made about maybe premature to do this with the current traffic patterns, et cetera, and McCarran's being developed. Walk me through how McCarran's going to affect it, the traffic flow, and why both of them, again, are needed.
Excellent question. And as another point of clarification, just within the last week and a half, maybe 2 weeks, all of our documents and information and studies have been placed on our website, including the traffic analysis, which we used, traffic numbers, the latest forecast from November 2010, which is the latest set of population data that's available. Now, to get to your question about McCarran and Southeast Connector, they are related for a section of it. McCarran only parallels Southeast Connector for roughly a couple of miles. The Southeast Connector is the last piece of an entire corridor stretching all the way from Pyramid Highway all the way down to Mount Rose Highway. It's 5.5 miles is this last section of the overall regional connection that this roadway would provide. Now, in our traffic analysis, as part of our response to the Army Corps of Engineers permits, and a lot of those were received under public comment, was the comments of McCarran being widened. It's being widened right now. Actually, I believe the construction starts next year. But why can't we just do that? That will help us in the short term. We're looking at long term. We're looking at 20 years out is what our traffic forecasting is currently right now. We ran some analyses under a no-build scenario. If you do not build the Southeast Connector, what do you need to do to the west part of McCarran east part, the east part of McCarran or the southeast part of McCarran? What is interesting is that human behavior comes into play here. When you add capacity to a project, traffic goes there. So right now we're proposing, or what starts next year is widening McCarran to 6 lanes. We ran a scenario where we widened it to 8. More traffic came to McCarran to the point of failure. We widened it to 10. More traffic came to McCarran to the point of failure. And what happened there is Longley Lane started seeing less traffic. They all started coming to McCarran. We could not get McCarran Boulevard wide enough to handle the capacity loss if the Southeast Connector is not completed. The only way we could go about doing that is converting McCarran to an interstate. That's the only way to move the volume of traffic that this area is going to see in the future if the Southeast Connector is not built.
Okay, thank you. One last question for Lee. Again, a central issue goes back to the core status, and you said 120 to 180 days. But you have an alternate plan if they don't approve that. So with the voting of the council today, one way or the other, and then the RTC tomorrow, tell me what the importance of voting now as opposed to 120 to 180 days from now.
Well, I think clearly one advantage to voting on it today and then voting on it tomorrow is to resolve the issue. We always find that right-of-way acquisition issues, property issues are some of the most contentious issues, and clearly with an affirmative action today by the City Council and affirmative action tomorrow, we get going, and the more we can secure things, clearly the better off we are. On the other hand, I mean, we could wait 120 to 180 days. I mean, we still have other parcels of property we need to acquire as we move forward. We have the Butler Ranch properties, some other private properties out there. We'll do those as we progress through the project. So we could theoretically wait, but it's been a desire of it's been a desire of the Regional Transportation Commission to move forward on this. So we're prepared to go with the direction of the respective boards.
Okay, thank you, Mr. Mayor.
Ms. Fraser.
Yeah, Lee, just while you're up there, because I want to make sure I understand this agreement, and one of the public comments was no truck traffic, for example. What if the council were to put into a condition during the master plan hearing that they approve the road but no truck traffic, or there was an access, for example, they cut off access to Mira Loma? Would that constitute a denial under this agreement?
That's a good question. I'd actually.
That's exactly what I'm concerned about.
Are you going to describe the trucks? Are they 18-wheelers
Yeah.
or are they local trucks?
Well, that's the whole point, Mr. Mayor, is that, again, without having this public hearing and without going through those motions of having the public input, I think the truck's a legitimate concern. I know, I live over in that neighborhood. For example, we have Mira Loma that says no truck traffic. And you go out there any day of the week, and there's a ton of trucks driving on Mira Loma. So if the council were to go through that public process, I'm just saying here,
Yeah.
and we decide to limit truck traffic or cut off the access to Mira Loma, there's been talk, I don't know if the council would approve that again. Most likely a future council is going to see this, but with that, we're being asked today to approve an agreement that's set in stone on this $7.5 million, and that's why I think this is so premature. We don't even have the answers to these questions today.
My first comment and reaction on first off, the Regional Transportation Commission is in the business of building regional roads. Those roads are funded with fuel taxes that are paid for by both motorists who operate passenger vehicles, but also trucks, freight operators, and whatnot. And I would want to maybe defer to legal counsel on that because I think there's going to be a right to access issue. I don't know of any regional road we've built where we've prohibited truck traffic. So I think there's an underlying legal issue because our goal in the regional transportation plan and in our regional transportation funding is to move all trip purposes and not deny anyone the right to use a road. So I think there's kind of a legal issue there that I would be first want to have perhaps the lawyers look at. So that's
and
kind
I'm
of.
sorry, Lee, I'm not trying to put you on the spot here.
I
I'm
understand.
just saying I think there's just a lot of unanswered questions here.
Yeah.
Again, before we get locked into this agreement
Do you want to talk about
without
traffic
having a
issues?
thorough analysis of what constitutes denial. Those are just a couple things that come to the top of my mind. I think Councilman Hashchef had talked about cuts and fills, but I don't know, over the next few months, there may be other issues that the neighborhood, I mean, again, 3 days notice, that the neighborhood comes forward with, and things that I haven't thought about here today that might constitute under this agreement some type of denial and then a repayment of this $7.5 million. So I think it's unfair actually to put both of our staffs on the hook here to determine what this agreement actually means.
I think those are excellent points to bring forward, and I know truck traffic is something that's been discussed quite a bit. And just from a point of clarification, there's the comment made that Lee and I differed in our statements and opinions, and I just want to clarify that in the presentations and interactions I've had with the residents, what I've stated is, what I've done is kind of role-played. If I was a truck driver and I'm making a delivery from east of the Reno-Sparks area to south of the Reno-Sparks area, what choice do I have? Do I want to stay on I-80 through the Spaghetti Bowl to 395, or do I want to get off onto a regional road where I believe the last count was they'd be hitting 11 or 13 traffic lights, a roundabout, other access points for businesses and residentials. And I was just role-playing and stating that a truck driver who's got on-time delivery issues, they're going to stay on the interstate, more than likely going 65 miles an hour where it's free-flowing traffic. Now, if an incident were to occur, would they want to use the Southeast Connector? I don't know. Again, if they had enough local knowledge to know that that road connected, possibly. But again, the discussions I had with folks was the over-the-road truck drivers making deliveries outside the region. Now, to take that a little bit further, our design, following design standards, will accommodate truck traffic. I mean, that's just the way the Reno City Manual is written as well. RTC follows that standard common practice to assume a certain amount of trucks are going to be on the road. I mean, for example, your trash hauling trucks, your moving vans.
So
now,
Garth, let's take that example though, and let's say the council says no truck traffic can exit on Mira Loma. I mean, truck traffic, Mira Loma is not designed for truck traffic. In fact, it's prohibited right now to allow truck traffic on there. So then, would that issue constitute a denial of an entitlement? These are just all the things that I think need to be flushed out in this agreement.
When it comes to whether or not trucks are prohibited on a city street or highway, and this is, after all, be owned by City of Reno. City of Reno passes ordinances that regulates traffic. RTC doesn't have anything to do with that. So if you wanted to pass an ordinance that forbids trucks on one of your streets, you can do it.
Including the Southeast Connector.
Including the Southeast Connector, as far as I can see. It'll be a city road. And within your jurisdiction. Not only will you own it, but it's within, of course, the boundaries of your of your city limits. I can't think of any other answer other than that.
Mr. Hashef?
Yeah, really, there's two issues here. One is, and the council's been very good about this, is to make it very clear, crystal clear, that we retain the right on the Southeast Connector not to approve it for all the reasons that Jessica just stated. Because we don't know until we see the project and we go through the public hearing process and hear from the neighborhood what issues we're going to have to deal with. And that is specifically reserved in this agreement. The other issue is, once we determine what that standard is, then in fairness to the RTC, they're not going to pay us $7.5 million, and then we're going to have the right to basically say no. We always retain the right to say no, but if we do and the project's denied as a result of it, then they would like their money back. And really, that's a multi-year process from here. We get the use of the funds, $7.5 million, and we still retain the discretion to say no. And if we do say no, then there's a refund. But we've had the use of the money interest-free. So here's, and I disagree with the RTC's position that it's covered, because the way I read it is that, in effect, and I'm paraphrasing, if Reno denies or refuses to issue the RTCA permit, let's just call that a special use permit for cuts and fills, then you read the rest of the language, and then it says for or an approval of the Southeast Connector. So that, to me, it could be interpreted that if you said no to a special use permit for cuts and fills, you're not moving forward with a permit for the approval of the Southeast Connector because you've denied that permit. That's the way, I read the language. So here's a suggestion. Jonathan, if you want to put that on the screen so people can see it. Because there's two parts here. One is if we deny a permit, and that results in prohibiting or denying the RTC the right to construct, the Southeast Connector, or we fail, and this is on the POP side, then under those two situations, then that would trigger the obligation for a refund. And I moved the time limit under Reno disapproval because that denial would have to come within 7 years. So that's a suggestion that I think addresses my concern and addresses the RTC's concern on, so if it has an approval or permit and that has the result of denying the construction of the Southeast Connector, that would trigger a refund. If we did anything with the POP to remove the Southeast Connector or denied a POP with the Southeast Connector in it, that would also trigger a refund. And those are the only two situations that would trigger a refund, and all of that would have to be done within that 7-year period. And to Jessica's point, because the last thing I want to do is hamstring a future council when they make that decision, and we retain the right to do that with the caveat that if we do, we have that right. If we do it, then, if it's within 7 years, we need to be able to budget and refund the 7.5.
I just like one more chance to read it because I was listening to you and
No,
both.
just read it. Take your time.
All right, thanks.
Why don't we take a 10-minute recess and y'all come up with your language and stuff, and then we'll come back. We're in recess for 10 minutes.
With that change that I moved up to Reno disposal would stay, Reno disapproval would stay there as well as in its existing location.
Yep, in both places. The other little one is on or before, where it says by 5 p.m.
Yeah.
Just change that, so.
Okay.
Mr. Fowler, you concur?
I do.
Okay. All right. Any other questions or anything? Mr. Ashef, would you give me a motion?
No comments? I thought...
Yeah.
All right, with those changes, Mr. Mayor, I would go ahead and approve the agreement that we're sending to the RTC. The other point I want to make, As Jonathan was kind enough to provide us with the minutes of the last set of meetings, and there were a lot of issues and concerns, so I'm incorporating really by reference those same issues about who pays what costs. Those are still in place because those provisions have not been changed in the agreement. And then, of course, we're adding the right to request the RTC to pay for the fill, and so that section's not entirely deleted, as I understand it.
Correct. That section is actually
Correct.
at the top.
So that would be my motion, Mr. Mayor.
Okay, do I have a second? I have a second. Discussion. Mr. Fraser.
Yeah, Mr. Mayor, I think it needs to be pointed out that this already had a master plan denial for a road to go through this area. So it went through a public hearing process and it was denied by City Council. And now we're going forward and we're entering into an agreement for $7.5 million. And I understand all the jurisdictions are having financial difficulties and the allure of having $7.5 million. I get that. But to put a future council in a box on a master plan, if they so choose not to approve the zoning for this road or a master plan amendment, I don't know where they're going to come up with $7.5 million in the budget. And I think that's just wrong. I think we're putting the cart before the horse. I think we should be going through the process that we normally go through, the public process on the alignment, on the road, get all the feedback and public input on the record, and make that determination by this council whether or not a master plan amendment is appropriate. And I don't know if I don't know if, Jonathan, you've had the time to look at that, but a regional plan amendment is necessary in this case. But I think there's a lot of pieces that we don't know. And I understand, Councilman Hashef, you trying to put in the conditions here. I appreciate that. I'm just very concerned about the slamming this through at this point in time for $7.5 million and putting a future city council on the hook for that before we've had a public process. The Corps of Engineers, I know, Lee, you had indicated the last meeting we had, I think you thought that we were going to have a determination by the Corps in March. I think we're going to, looking at the record, I think it's going to be much longer than then. Based on the public documents that have been provided. There's over 200 pages so far. It hasn't even gone through the public hearing process with the Corps of Engineers. And I'm very concerned about moving forward with this agreement today.
Any other comments?
No, I just wanted to make it crystal clear, because I don't want the record to be muddy on this point, that the council, whether it's us or any future council, retains 100% discretionary right and approval. No public hearing process is going to be compromised. They will have to go through the public hearing process to the extent any permits, entitlements, et cetera, are required.
For the record, John Shipman, legally, yes.
How many public comment sessions have you had, Mr. Lee, or?
Mr. Mayor, Lee Gibson, RTC. Garth, come on up, because we've had, I do know that the Southeast Connector is part of our current valid regional transportation plan.
Right.
The alignment is stipulated on there. We did go through an extensive public process with respect to adopting that plan. I should also point out for the record, last year, about 18 months ago, at the request of Councilman Dave Azi, and at that time he's still a commissioner with the RTC, he requested staff conduct a sensitivity analysis of all of our projects, major projects in the RTP. That analysis showed that even with the economic slowdown, all of our projects still meet their purpose and need requirements, and we in fact did not see any change in the design concept and scopes for those projects, even with the economic slowdown. We did present those findings in a number of public meetings and did get public comment on that. So we've had a number of instances where we have had the public review our regional transportation plan. It is also my understanding that the city's master plan incorporates our regional transportation plan. It's also my understanding that our regional transportation plan did go to the TMRPA for a conformance finding, and the appropriate approvals were made by TMRPA. Okay. So our regional transportation plan conforms with all local requirements. and federal requirements with respect to its composition.
Okay. Do you have anything, Garth, to add? Okay, thank you very much. Any other comments? I have a motion, I have a second.
Just, Mr. Mayor, a follow-up on that. We've had 0 public hearings on an actual master plan amendment in design of the road. So I understand there's been a lot of public hearings on the actual alignment, but we have not had any public hearings about the master plan change or the design of that road at this point in time. So I think that, again, we're not doing that process.
Any other comments? You have a comment to?
Forgive me, I'm maybe a little unclear on this. I'm not, are you speaking of a master plan public hearing specifically for City of Reno?
In front of this council, Garth, for a master plan amendment and zone change, we have not had a hearing since the council did in 1996.
And I'm unaware of, I'm aware of the ordinance you're speaking of, the one that was based off of is actually a study that RTC did in 1992. And it took a while to work through the process, and the ordinance was done in 96. But I believe that was a City of Reno led ordinance change. It wasn't something normally done as an RTC project because it was Reno's master plan. Reno took the step to amend their master plan. It wasn't something that's normally done as an RTC project. Our projects are done with the interlocal cooperative agreement. That's where they're given to the local governments for their approvals. I'm unaware of where we've done that in the past. So we could definitely help facilitate that or work with you on that, but I'm unaware of RTC's ability to ask the cities and county to adjust their master plans.
Okay, thank you very much. Ms. Adler.
Jonathan, I just need to hear you say again, or with a correction if that's appropriate. The action that could be taken today would put no constraint or restriction on any future council action as it relates to the truck, any action that would follow from this decision wouldn't constrain a future council or require that they vote in accordance with today's vote, correct?
Correct,
Affirmatively.
correct. Yeah, and to be clear, yeah, correct. I'm just going to leave it at that, yeah.
What was the to be clear? Go
no,
ahead.
I mean, under this agreement, the city council retains complete and utter legislative discretion. You can have hearings, issue permits, et cetera, et cetera, et cetera. And there's nothing by contract that would tie your hands at all. With that said, there's a $7.5 million reimbursement requirement if certain actions are taken that result in certain consequences. If a permit is denied and the denial of that permit stops the project, period, council had the discretion to do that, and this agreement did not encroach upon that. However, the consequence is the city's going to have to pay back the $7.5 million, again, if it's within that 7-year period, and as we've talked about before. And I just want to, there's a distinction legally that I just need to make sure that you're understanding that. So there's going to be a financial incentive out there as far as the $7.5 million goes. So.
Okay. Yes, sir.
Just one question real quick for Lee. On the process you guys are going through, how long before you think you'll be, I don't know if you've already determined what other approvals you'll need from the city, or I'm assuming you're going to need cuts and fills approvals. I don't know if you've gotten through that analysis yet. Yeah, no,
Anything else?
Well, I mean,
typically, and I'll defer to Garth, but typically we let our contractor, after we've awarded a construction contract, deal with the fill and cut permits.
Okay.
So those are generally the matter, a matter for
I guess
them to deal with.
where I'm trying to get is how long do you think it'll be before you guys know what additional approvals you need from the city and when you would be back in front of us?
Do you have a quick answer, Garth?
Yeah.
6 months, 3 months? 6 months.
So by 6 months from now, we'll know whether this $7.5 million has to go back to you guys or not. We should have that. We should be through that process.
Potentially.
Right? I mean, by then, all the approvals should be done. Everything should be worked out, and you guys will know whether we've approved the permits or not.
We'll be moving through final design, so we'll have a refinement on the quantities and issues that would potentially require cut and fill permits, and yeah, we should have that done in 6 months.
Okay.
Have a motion and second. All in favor say aye. Those that oppose, no. Show the vote. 1, 2, 3, 4, 5, 1. Mr. Izey is absent. All right, any other, we'll go before, Yeah, public comment, any public comment cards? Okay, Chair will entertain a motion to adjourn. Have a motion second. All in favor say aye. Those that oppose, no. Motion carries unanimously.